Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers failure to identify 911 calls and reasonable suspicion, and is brought to us by Love Everyone's channel. Be sure to check out the description below and give them the credit that they deserve. This episode was also brought to us in cooperation with the ASD Docs channel. Be sure to head over to his channel after watching this episode and check out his video covering the storyline of this interaction in depth. On July 26, 2019, officers from the Lufkin Police Department responded to a 911 call from Lufkin, Texas resident Christy Davis reporting that 37-year-old Joshua Frazier was parked in her driveway in a manufactured home community at Whippoorwill Drive. When the first officer arrived and approached Mr. Frazier, he was standing outside of his vehicle with the driver's side door open.
How's it going, man?
All right.
Oh, you stay out here?
No, I'm thing it came loose. I'm waiting on the dude to come fix it. To put it in reverse.
Alright, so the guy that,
Yeah, I just got off the phone with him. I know she probably called y'all.
where'd he stay at?
Oh, he coming off on about Solace.
Why y'all meeting here?
Oh, because I can't put it in reverse. My girl ship thing.
Okay, what brought you here, though? You say you don't stay here. What brought you over here?
Oh, I came to pick up my little cousin. And when I went to try to put it in reverse, it wouldn't go in reverse.
Okay.
So this is it. So he finna come.
Your little cousin? Is it her?
Yeah.
Okay, where'd she stay at?
Oh, she was in the front.
She was in the front? Okay. You don't have any weapons or anything like that on you, do you?
Nah.
Keep your hands up over here. Put your hand up there.
Hold on.
Don't.
Just let's
Yeah.
just
Hold on.
raise your shirt and show us you don't have any weapons.
No, I ain't got no weapons.
All right. I can see something bulging over there. Just making sure. Don't reach in your pockets or anything like that. What's your name? What's your name?
No, this is uncalled for.
No. We get a call on you. We got to ID you. So what's your name?
I'm not doing nothing wrong.
Is this your property?
Although the officers allege that they need to identify Mr. Frazier because they received a 911 call about him, Texas law did not require Mr. Frazier to provide his name in this situation. Section 38.02 of the Texas Penal Code states that, quote, "A person commits an offense if he intentionally refuses to give his name, residence address, or date of birth to a peace officer who has lawfully arrested the person and requested the information." Because Mr. Frazier was not under arrest, he could not be charged with failure to identify. The officers also seem to imply that Mr. Frazier is trespassing, asking him, quote, "Is this your property?" Section 30.05 of the Texas Penal Code states that an individual commits the offense of criminal trespass if the individual, quote, "enters or remains on or in property of another, including residential land, agricultural land, a recreational vehicle park, a building, or an aircraft or other vehicle without effective consent, and the person had notice that the entry was forbidden, or received notice to depart but failed to do so." The statute defines notices as, quote, "oral or written communication by the owner or someone with apparent authority to act for the owner, fencing or other enclosure obviously designed to exclude intruders or to contain livestock, a sign or signs posted on the property or at the entrance to the building, the placement of identifying purple paint marks on trees or posts on the property, or the visible presence on the property of a crop grown for human consumption." Here, it does not appear that Mr. Frazier was on notice that entry was forbidden, so any trespassing charge would have to stem from remaining on the property after receiving notice to depart. In the 1988 case of Reed versus State, the 6th District Court of Appeals of Texas defined the culpable mental state required for a criminal trespassing conviction as, quote, "a volitional refusal to leave when requested," and several other courts in Texas have adopted this standard. While there is no readily available case law on this specific issue, if Mr. Frazier were charged with trespassing, he could defend himself by arguing that he did not volitionally refuse to leave since his vehicle was not operational.
Why don't you want us to give us your name?
Because I'm not
You got
doing.
some tickets or something?
I'm not doing nothing wrong.
We're just responding to a call from citizens that once said there was some problems over here.
Oh, it's not no problem. As you can see, it's not a problem.
Okay.
I'm not causing any problems. I'm not doing nothing. I'm not hooping and hollering. I'm not causing any problems. I'm not doing none of that. So
Well,
I'm
the
waiting.
officer needs your name for his report. Is there a problem with that? Are you wanted for something? Are you a fugitive from justice?
She's not really young.
You have a child in the car with you?
They're to check welfare on the child. You have the right to find out who the people are that are involved.
It's not that going on. It's somebody involved. What is, I mean...
You're involved.
Is there a reason why you don't want to give your name?
Huh?
Why don't you want to give your name, man? And
We're not
this
here to harass
take you 5 minutes to get out.
So we can go. You give us a name, we can get out of
I just
here.
told you.
We have to identify everybody we come in
I
contact
have not
with.
committed a crime, sir. It's not a crime. It's not an offense. It's not nothing going on.
We had a call concerning you being in this vehicle and possibly being intoxicated.
The officers inform Mr. Frazier that he is being detained on suspicion of intoxication based on the information provided in the 911 call. As we've discussed many times on ATA, a police officer cannot legally detain an individual unless they have a reasonable suspicion of criminal activity. However, this reasonable suspicion does not have to be based on the officer's personal observations. In the 2014 case of Navarrete versus California, the U.S. Supreme Court held that a 911 call can provide the reasonable suspicion necessary to justify an investigatory stop if the tip demonstrates, quote, sufficient indicia of reliability, and, quote, creates reasonable suspicion that criminal activity may be afoot. Based on the 911 call, the police likely had reasonable suspicion to initially detain Mr. Frazier on suspicion of public intoxication and driving while intoxicated. Section 49.02 of the Texas Penal Code states that, quote, a person commits an offense if the person appears in a public place while intoxicated to the degree that the person may endanger the person or another. While the driveway was not public property, Section 1.07 of the Texas Penal Code defines the term public place as, quote, any place to which the public or a substantial group of the public has access. In the 2000 case of Loera versus State, the 5th District Court of Appeals of Texas determined that, quote, if the public has any access to the place in question, it is public. The key to determining the sufficiency of the evidence in this case turns on the meaning and application of the term access, not on the common understanding of the term public. The court concluded that the walkway between a driveway and the front door of a home could be considered a public place when it could be reached by a public road or street. Based on this reasoning, it seems likely that a court would conclude that Ms. Davis's driveway was also a public place. As for driving while intoxicated, Section 49.04 of the Texas Penal Code states that, quote, a person commits an offense if the person is intoxicated while operating a motor vehicle in a public place. In the 1995 case of Denton versus State, the Court of Criminal Appeals of Texas clarified that to operate a vehicle in violation of the DWI statute does not require that the defendant cause the vehicle to move. Instead, the court concluded that, quote, the totality of the circumstances must demonstrate that the defendant took action to affect the functioning of his vehicle in a manner that would enable the vehicle's use. Based on this definition, a court would likely find that Mr. Frazier's alleged actions of starting the car and taking the vehicle in and out of park and reverse constituted operation for the purposes of the DWI statute. However, while the officers probably had a reasonable suspicion to detain Mr. Frazier based on the 911 call, he did not appear to show any indications of intoxication during the altercation, and the officers did not conduct any further investigation to determine if he was intoxicated, making it possible that a court would find that the officers could not legally continue to detain Mr. Frazier after seeing that he did not appear to be intoxicated.
Man, yeah.
So right now you're detained. You're being detained.
Come on. No, sir. No, sir.
As far as
There's
that goes, you have to give us your name or you go to jail for failed ID. That's where we're at right now. Okay? If you were walking on the sidewalk or something, that's one thing.
I have some tickets.
Okay, well, we're not worried about some tickets, man. Class C tickets, traffic stuff? We're not worried about that. What's your name? There's a few Class C tickets that cost you 30, 40 minutes in the jail. There's a whole lot different than a failed ID fugitive charge, which is a misdemeanor A.
I'm not doing nothing wrong. So if
So
I mean,
do you want a misdemeanor A charge or you want some traffic ticket charges? Because we're not worried about traffic tickets. We just need to identify you so we can do this investigation and get out of here.
Mr. Frazier tells the officers that he does not want to identify himself because he has traffic warrants, which courts have generally found to be sufficient grounds for an investigatory detention based on reasonable suspicion. For example, in the 2014 case of State versus Johnson, Division 5 of the Eastern District of the Missouri Court of Appeals determined that the fact that the defendant stated, quote, I think I've got some traffic warrants, gave the officers reasonable suspicion to detain him. Similarly, in the 2017 case of State versus Bateman, Division 1 of the Arizona Arizona Court of Appeals found that after the defendant volunteered that there might be an outstanding warrant for his arrest, the detectives had reasonable suspicion to detain him by directing him to sit on the curb. Even though Mr. Frazier's admission about his warrants likely gave the officers reasonable suspicion for a Terry stop, as we discussed earlier, Texas's failure to identify statute does not require an individual to identify themselves unless they are arrested. While the statute does allow for a harsher penalty if the individual was a fugitive from justice at the time of the offense, it does not modify the requirement of an arrest for fugitives. When a warrant is issued for an individual's arrest, Article 15.06 of the Texas Code of Criminal Procedure states that any peace officer is authorized to execute it in any county in Texas. However, the law is less clear on whether police officers are obligated to conduct an arrest on an outstanding warrant. Article 2-13 of the Texas Code of Criminal Procedure, which explains a police officer's legal duties, states that, quote, "The officer shall execute all lawful process issued to the officer by any magistrate or court." While an arrest warrant would be considered lawful process, the law limits the duty to execute the process to the officers to whom the warrant is issued. Unfortunately, there is no case law that investigates this issue, and while there is certainly an argument that officers have the discretion to choose not to arrest someone with an existing warrant, officers are always authorized to make an arrest based on an outstanding warrant.
What are you investigating? Investigation
You call
is...
for service that has got 4 officers here now.
You already admitted that you don't have any reason being here other than your car's
And
not
you're
working.
parked
I mean,
up here
I'm
If
not
somebody
gonna
else
be
is-
crime. Also,
Okay.
you get called when there's
Possibly
a
intoxicated.
crime. How am I
So,
possibly?
now we're
Come
looking
on.
at a PI charge.
No, sir. No, sir. How can I be
Okay.
Why do you not want to
intoxicated?
cooperate? What is the big deal about not saying your name?
I'm gonna do a pattern.
I mean,
Because he wouldn't let me do a pattern. Okay. I want to make sure you don't have any weapons on you. Don't reach for
sir,
anything.
hold on.
One of the officers approached Mr. Frazier from behind to pat him down for a weapon, and Mr. Frazier turned around to protest. The officers then grabbed Mr. Frazier's arms, pressed him against the vehicle, and informed him he was being arrested for resisting a search. While Mr. Frazier was pushed up against the vehicle, one of the officers pepper sprayed him. After placing Mr. Frazier in the back of the police vehicle, the officers interviewed the woman who was in the vehicle with Mr. Frazier, who provided the officers with Mr. Frazier's name and confirmed Mr. Frazier's statements that he was in the neighborhood to pick her up and that his vehicle would not go into reverse. According to the Lufkin Daily News' arrest reports for July 28, 2019, Mr. Frazier was arrested for resisting arrest, search, or transport, and on 2 warrants for no driver's license, 2 warrants for driving while license invalid, 2 warrants for no insurance, a warrant for parking facing traffic, and a warrant for no license plate light. On August 6, 2019, Mr. Frazier was charged in the Angelina County Court at Law Number 1 with a Class A misdemeanor for resisting arrest, search, or transport in violation of Section 38.03 of the Texas Penal Code. As of the date of this episode, the criminal charges against Mr. Frazier are still pending. Overall, the Lufkin Police Department officers get a C-, because although they were likely within their authority to detain, pat down, and investigate Mr. Frazier, the officers demanded to see his identification without a lawful basis for doing so, failed to conduct a proper investigation into the original complaint, and misrepresented the statutes for trespassing and failure to identify. As mentioned before, the Lufkin officers had acquired reasonable suspicion to investigate Mr. Frazier by both corroborating the evidence provided by the 911 caller and through Mr. Frazier's verbal admission to being a fugitive. And when the officer approached Mr. Frazier to conduct a Terry frisk, he was well within his authority to do so. Mr. Frazier's physical resistance to the pat-down search was the catalyst to this stop's escalation, and it is difficult to fault the officers for deciding to physically restrain Mr. Frazier. That said, the officers focused a majority of their investigation on forcing Mr. Frazier to identify himself when he was not lawfully required to do so, and at no point did any of the officers attempt to question the 911 caller or the woman who was in the back of Mr. Frazier's truck before demanding to see his ID. If the officers had taken the time to make contact with the 911 caller and question Mr. Frazier's passenger, then the officers may have realized that he was stranded there and no crimes were being committed. The officers also inaccurately accused Mr. Frazier of trespassing and used accusatory language to gain control of the situation rather than expressing a desire to help and attempting to understand exactly what was occurring. While much of the Lufkin officers' conduct was legal, it was also ethically and professionally questionable, and there was likely a path to a peaceful resolution to this encounter had the officers not attempted to force Mr. Frazier to identify himself. Mr. Frazier also gets a C-, because although he was within his rights to withhold his identity, he provided the officers with reasonable suspicion by admitting to being a fugitive, refused to obey the lawful commands of the officers, and physically resisted the officers when they attempted to conduct a lawful Terry frisk. It is easy to understand why Mr. Frazier was so hesitant to engage with the officers, but I struggle to understand why Mr. Frazier would resist a pat-down frisk when no drugs or weapons were found on his person. It is clear that Mr. Frazier was doing nothing illegal when he was initially contacted, but the moment he admitted to having warrants, he granted the officers the authority to detain him and conduct a Terry frisk. Although the officers likely had acquired reasonable suspicion without this admission, his reluctance to remain silent only further motivated the officers to ascertain his identity, and the officers would have been within their authority to detain Mr. Frazier until they were able to identify and arrest him. At the end of the day, Mr. Frazier did physically resist the officers and did have warrants for his arrest, and he likely would have been apprehended at some point regardless of the circumstances. It would have been within his best interest to comply with the officers and clear up any outstanding warrants within the courtroom, rather than stacking up additional charges by resisting an inevitable arrest. Thanks again to ASD Docs for contributing to this episode. And if you'd like to learn more about Mr. Frazier's story, including an exclusive interview, documents relating to the arrest, and the original 911 call, then be sure to check out ASD Docs' video covering this interaction. You can find a link in the description below. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching. And don't forget to check out the ATA Patreon page for more police interaction content.